So it's a great pleasure to have another interview in the Global Law program at Direito FGV SP. And today I have the pleasure to interview Professor Mia Caielli from Università Di Torino. Professor Caielli is an expert in freedom of speech and public law, comparative public law, feminist studies, and also she has been giving courses on the protection of fundamental rights and anti-discrimination. So it's really a great pleasure to have you here, Professor. And she is currently offering a course on hate speech and freedom of speech, which is a very hot issue, not only in Brazil, of course, but also in Brazil. We are facing very big challenges concerning this issue. And to start our conversation, I think it would be useful to ask you a very basic, but sometimes very controversial question, which is, what do you understand by hate speech? Some people try to, in a way, make a confusion between, for example, expressing with hateful words as a synonym of hate speech. So, in your view, how should we define the very concept of hate speech?
Thank you, Professor Macedo. Just let me say that I'm very glad to be here, and I would like to thank FGV and the Global Law Program. So it is a pleasure to dialogue with you and with the students and other scholars here on this hot topic. And I know that it's hot in Brazil, and it's hot in Italy, and it's hot, almost everywhere. With regard to the difference between unpolite speech and hate speech, I would say that even though there is not a universal and unique definition of hate speech, most of jurisdictions tend to define it as an expression which can be oral or written, can be symbols, can be gestures that have the purpose or effect of denigrating, humiliating, inciting hatred, inciting discrimination against the member of certain groups or categories. So it's more than something unpolite or morally unacceptable. It's something that has some effects on the target.
Okay, but if you compare, for example, with some kind of hate crimes, mm-hmm. For example, discriminating someone, impeding someone to get into a shop or a restaurant, which is classic example of racism and discrimination, there's a difference here between hate speech and direct discrimination, isn't it?
Yes, and thank you for this question, because it's a very interesting one. Because discrimination in employment or in the access to goods and services is not a crime. It's usually not a crime. So it's, I would say, a civil offense. So it is prohibited under most of European jurisdictions and legal systems, but it's not a criminal offense. So that is the difference. Hate speeches, when a legal system bans hate speech, de facto he's going to introduce in a criminal offense of discrimination, which is kind of a paradox. And this is one problem. Then, when it comes to hate crimes, in my opinion, the difference is pretty clear, because hate crimes are criminal offenses under the existing criminal law provisions of a state. So they are criminal offenses, but they are committed with a biased motive. And they become hate crimes, meaning that they are punished more than ordinary crimes. So there are some aggravating circumstances in the criminal code. But these are ordinary crimes committed with, a bias or an intent of discriminating against someone.
And they, as far as I know, they're not exclusively realized or done through expression, through speech, isn't it?
Yeah.
For example, if you create some barrier to someone to get a job, something like this, you are behaving concretely and not just expressing words when you do this.
Well, I would say that hate speech is expressing words. I mean, it may be written, but could be a newspaper, could be a blog, because now it's more blog or Twitter messages or Facebook posts or stories on Instagram, but it is speech. It's not a conduct, a behavior, it's just a speech, but the speech must be public, of course, and the audience should be a pretty big audience. So it's a speech directed to the public and affecting some specific members of certain categories.
Okay, let me ask you a final question concerning the very concept of hate speech, which is many theorists and especially a lot of feminists tend to make some kind of similarity or consider pornography as a species of the gender hate speech. I'd like to know what are your opinions about this and whether there is some kind of specificity on how to deal with pornography in case it is considered a species of hate speech.
Thank you. This question is particularly challenging because I don't have the answer. I mean, I've been thinking about Catherine McKinnon ideas of pornography as a form of hate speech. I would say yes, I kind of agree with assumptions, but then I'm not completely sure that pornography can be considered as a hate speech in the sense, in the legal sense. I mean, in the legal sense. I have some difficulties, but I do understand that there is a very close link between hate speech and pornography in the sense that pornography reproduces and perpetuates stereotypes, stigmatizes, and of course is a way of objectifying women. And this is exactly what misogynist hate speech does. So in this sense, they are very, very similar, but I'm not completely sure that porno video is a form of hate speech. And I'm not aware of any jurisdiction punishing it, so...
Yeah, that's also true. I mean, usually the legislation try to give at least a different standard on how to deal with pornography compared to, I don't know, typical hate speech like racist speech.
Right. No.
Okay, let me ask you another thing, which is, in your opinion, what are the main currents in European law as far as hate speech is concerned? What is going on? What are the new trends?
I can say that in Europe, a lot is going on because we have, of course, several states, and they all have their own legislation on hate speech, and almost all of them have one. But it depends. I mean, some countries punish hate speech, racist hate speech, sometimes religious hate speech, and that's it. While we have a lot of countries that began to punish also, for example, homophobic, transphobic, and misogynist speech. And there is a debate over the expansion of hate speech bans. This is going on. And then we have the European Union system, and this is a very interesting one. There have been a few recent cases on addressing hate speech, but especially online forms of hate speech and sometimes fake news. While in the European Court of Human Rights, which is more or less the same organ as that is present in the inter-American system of human rights, like the Commission and the Court, Well, this court is approaching hate speech in a very interesting manner. So the European Court of Human Rights is adopting an approach that is clearly departing from the US approach. There is no understanding of, for example, when it comes to fake news, there is not an understanding that false ideas are protected under the Constitution or the freedom of expression. And there is not this US idea that internet is the new marketplace of ideas, not at all. Moreover, what I can say is that the Strasbourg Court, that is the European Court of Human Rights, together with the Court of Justice of the European Union, are kind of developing a sort of European First Amendment. So a new understanding of the freedom of expression as they approach hate speech with a victim-centered approach. So they look at the victim, and their basic idea is hate speech bans do not undermine democratic legitimacy. They do not, they contribute to the effectiveness of anti-discrimination provisions. They do not undermine their legitimacy. So this is the very famous Dworkin argument and Post argument. I wouldn't say that the European Court of Human Rights is adopting this point of view. So a victim-centered approach and an idea, an assumption, the most recent assumption is hate speech is not just a speech. It is an act, it is a conduct, and it is concrete. So there's not the search for an act of violence or a concrete crime. Hate speech can be punished as such, as a statement that denigrates people and humiliates people. So I would say that this is a revisitation of the classical liberal understanding of freedom of expression, and it is an understanding that goes together with the promotion of substantive equality in the European regional human rights system. So concrete de facto equality, and one of the instruments is considered the prohibition of hate speech towards certain minorities, and especially in the recent years, transgender people, homosexuals, and women, while it is now clear that racist hate speech shall be punished. And yes, maybe I could add that these all began with the prohibition by national legal systems, and a prohibition that was upheld by the European Court of Human Rights of historic negationism or denialism. So people who, for example, deny the existence of Holocaust are punished under most of European countries, and the European Court of Human Rights ruled that these laws are compatible with the European Convention on Human Rights and with the freedom of expression. So these are limits, as the court says, that are necessary in a democratic society. So this is the current approach.
Let me ask you, you mentioned something which I think is very important, which is the fact that hate speech regulation or the ban of hate speech usually focus on the content of the speech and not only on the possible or the threatening effect, like, for example, the act of inciting a crime, which is usually considered a crime everywhere. It's not really controversial. Even in the United States, incite a crime is not protected by freedom of speech. But I wonder how would you, for example, frame the argument usually put on the table, for example, on why not, for example, criminalize the denial of the Armenian genocide, which is something that is also put on the table, or the genocide promoted by, I don't know, Mao Zedong or Stalin, which is usually not something considered at the same level?
Well, good question, because the parent check decision of the European Court of Human Rights is a very controversial one. Well, in this decision, as you mentioned, the court said basically that the Armenian genocide is not protected under the denialism regulations. And the reasons are, well, of course I do not agree with the reasons, but basically the European Court of Human Rights explained that there is not a European consensus around this happening as a genocide. And so this decision has not been overruled yet, and it is true, this genocide has not been considered as such. And so it is possible under Europe to deny it and not be punished for that. Well, it is the problem of hate speech bans that they tend to expand, and it is maybe, I think that one of the reasons is that each legal system and each regional human rights system tends to focus on the most direct experiences with human rights violations. And I guess that the Armenian genocide was felt as something that happened far away and was not understood as something as Holocaust. But of course it's questionable. Of course it is.
Okay. Let me add another polemical question, which is, for example, I wonder if there is some kind of double standards as far as, for example, freedom of religion and freedom of religion speech is concerned, and compared with the non-religion kind of speech. For example, the speech criticizing or denigrating homosexuals. Is the European law usually, let's say, accurate in framing someone who is a priest or religious leader who says that, I know, homosexuals are sinners, are under humans in a sense, and the same kind of content of speech when it's said by a non-religious leader person?
This is a very debated issue in Europe and especially in Italy. So to be clear about it, I have to say that in almost all the bills that have been proposed before the Italian Parliament to tackle homophobic and transphobic speech, somehow an amendment was adopted in the process of approving these legislation that were never approved. And this amendment concerned exactly what you were saying, the possibility to, they make it clear that the church and religious organizations and the members, the priests and so on, have freedom of expression and can criticize homosexuality or transsexuality and so on. So they can do that. It's a sort of saving clause that is made in order to let it possible to have a law, but this was not sufficient. And this happens in Italy, but I can tell you that when it comes to the enforcement of European Union anti-discrimination law, religious objections do not matter, because there are several cases that are not cases of hate speech, but cases of discrimination. Well, the claim I discriminated against an homosexual because I'm a Catholic doesn't count at all, and the court punish the perpetrator, or the person who has a discriminatory conduct, even if his or her justification is I did it for my religious belief. These don't matter anymore. According to, for example, the Court of Justice of the European Union, UK courts, there are several cases. And I would say yes, UK has a lot of cases on this. Like, for example, civil servants that refuse to celebrate gay marriages. Because they say it's conscientious objection, and they say, well, we are Catholic, we don't want to perform this job. But this does not count. They say, you're a civil servant, you obey our legislation, and our legislation allows same-sex marriages, so it's your duty.
Yeah, but these cases involve a conduct, as you said.
It is, yes. It's not
they involve
speech.
more than speech,
right.
Or a different kind of behavior.
Yes, I think that, well, maybe the manner counts, the way you say it, because hate speech bans do not prevent priests when they say the Mass to say the homosexuals are sinners. I'm positive about that. But it punishes people who say this in public, in a broader audience, with different words, and in different words, and not in a certain specific context that is a church.
Okay.
So yeah, I think that much depends on the context and the audience.
And Professor Caielli, where do you think the winds are blowing now? I mean, do you think that European law is becoming more liberal or more egalitarian as far as, for example, free speech is concerned? Where is it going to? And if you could add a sub-question, is how Italian law is also on the same tune with European law?
Well, I'm pretty sure that European law is going towards an egalitarian approach. And all new regulations and directives seem to go in this direction. For example, just to give you a very concrete example, the European Union institutions made the major IT platforms, IT companies, to agree in a code of conduct. And they are obliged to remove illegal content, online hate speech, illegal advertising, or content that are false or that are misleading, and they all agreed. So we have a self-regulation model, but in last year, the European Commission was asked to adopt a new approach, which is not only self-regulation, but much more than that, because of the COVID-19 pandemic, that in some way magnified the online disinformation regarding the disease. And so the problem of online speech, fake news, and hate speech as well became a very, very important issue. And the European Commission has proposed a new bill, and it should be adopted before the end of this year, which is the Digital Services Act, which is a regulation, so it's legally binding. And it has something to do with content moderation, removal of illegal content, and so on. So this is the approach. And with regard to Italy, well, we do have hate speech bans, we have hate crimes. These are punished by the criminal code. We are struggling over the expansion of hate speech bans because now they are punished if they are directed, if hate speeches are directed towards religious, ethnic, and national minorities, and that's it. So the struggle is for transsexuals, transgender people, and homosexuals. So the LGBTI issue is an hot issue, a very
Catholic
hot issue.
tradition
yes,
is there.
Absolutely,
Strong
I think so. Yeah, I think that this is the problem, basically. Yeah,
that's the problem. So one final question, which I think it's very also challenging and very disturbing, at least in Brazil. Maybe it's also the case in Europe, which is the fact that we are now facing, in many jurisdictions, some kind of inflation of the invocation of the principle of dignity as a kind of joker in the hermeneutical struggle, in which everywhere people make an appeal to the offensiveness of some speech, to the idea of dignity, and it also argued by more liberal authors that the denial of free speech is a violation of the dignity. So I wonder, how do you see this sometimes, at least, very ad hoc kind of clash between principles and the arbitration on how to deal with them? And in some jurisdiction, I'm aware that this is the case in most of the European countries and also in Brazil, the invocation of, for example, of the proportionality test, it's a kind of mantra among the majority of the constitutionalists. How do you see this? Don't you think there is some kind of threat of an excessive overinterpretation or some kind of disguise of pure discretion that lies behind this unprincipled application or invocation of the basic principles?
Yes, this is true. Dignity is playing a crucial role everywhere, and also in Italy. Even if our constitution, our constitution mentions dignity, but does not contain a specific provision on human dignity like other European constitutions. But nevertheless, Italian courts are insisting on the protection of human dignity. What I think is that, and dignity, as you said, it is often considered, for example, some Italian scholars stated that dignity shall be considered as a super-constitutional value. So it means that the proportionality test or the balancing between competing fundamental rights doesn't work here, because dignity wins, and wins, so it's not necessary to make these balancing and to assess the reasonableness. Okay. What I think is that, at least in some jurisdiction, I'm not saying everywhere, but dignity is invoked as an instrument to implement what is already written down but has not been properly implemented, which is equality intended in a certain way, which is not formal equality, is not even substantive equality, is much more. Is what, for example, in Latin American new constitution is called transformative equality. So something that has the aim of subverting power hierarchies. And since maybe it's not written down in a clear manner, some judges begin to reach this goal invoking dignity, because dignity is very simple to understand. It's something that we all know something about. It's a very powerful word. So even if it's not written down in the Constitution. So I think it's something that revolves around the notion of equality of human beings. And it is considered maybe as an instrument to implement equality as it should be implemented in our social, liberal but social democratic constitutions.
Okay, well, while we were answering this, I remember an important question, and this is truly the final one, which is, I would like to move a little bit to another subject, which is your specialty, which is feminism. And how is the situation now of the feminist scholarship in Italy? I mean, is it a hot issue? What is going on? I'm aware that you have been teaching and researching the subject. So what is the situation now?
Well, the situation of feminist thinking in Italy is it's pretty interesting right now because, well, new generations of feminists are expressing really new versions, visions of what is feminism. And there is a sort of, it's not really a dialogue, but is sometimes a clash between, I would say, veterans and new, younger feminists. And this all was really very evident during the procedures, the parliamentary procedures in order to approve the bill on hate speech, because this bill intended, just to give an example, intended to punish misogynist hate speech, and many feminists did not agree with that, or at least they said, well, we do not agree because women are not a category, are not a group, and are not a minority, which is true, of course. I totally agree with them, but basing themselves on this assumption, they say, so we do not want a specific law treating us like we were a group, like LGBTI people or an ethnic minority. And on the other side, other groups, other movements, feminist movements or feminist scholars reacted to this and say, hey, we need protection because gender-based violence is increasing. Political, I would say, I call it political violence against women, is very, very high in Italy at the moment. Cyber harassment is there, and we need protection. So let's go for that. And then there is another. Well, this is also very interesting and has to do with hate speech as well. Some of these veterans feminists were considered to be transphobic in the sense that they don't like to be, I'm oversimplifying, but to be together with women that were not born women. So they say their basic claim, which is a very interesting one, is body matter. It's not about self-identification in one gender or in another, because the body you are born in matters and should continue to matter. But younger people say no. Self-identification and gender fluid is the new, I don't know, maybe pretty common idea. And there is a clash. And it's pretty interesting. And yeah.
This is quite interesting. Well, I think we could stay here for hours discussing these and other issues, but we have to stop. I'd like to thank you again for this interview and thank you for coming to Direito, FGV Direito SP, and to offer this course on this such a hot topic, hate speech, especially during our this time. We are approaching the electoral moment in which hate speech tend to get a higher temperature. So thank you very much. It's really our pleasure to have you here. Thank you, Professor.
Thanks to you. Thank you very much.